I am seated here today to give my ruling, my reasons for the rulings we have made in the presidential election petition, which was withdrawn recently. I instructed my staff to put my ruling here for delivery. The Chief Justice and the other members of the quorum have opted not to be part of this afternoon's proceedings, and I respect their decisions. However, what is of surprise to me is that my file has apparently been confiscated on the orders of the Chief Justice. I am going to proceed in the court building to recover my file, and I'll come back and read my ruling today as scheduled.
There's opening here. There's an opening here.
That has to be read. However, these files that having been called this morning, I am proceeding to read my consolidated reasons for the decisions I arrived at in the applications that were made in this petition. Before I read, I want to note that my file has been confiscated by the Chief Justice of Uganda. But nevertheless, I'm working from a duplicate copy. I'll not be able to read everything in my ruling, but I'll make an effort to do what I can. So, Council who are remaining, please introduce yourselves. Before I give my reasons, I wish to put on record the unfortunate developments of this afternoon, where the Chief Justice of Uganda has attempted to gag me by denying me the opportunity to read a ruling detailing my reasons for the decisions I arrived at in the petition that was withdrawn. As some of you who are here this morning know, the court convened with all the members of the quorum, and the Chief Justice directed that the rulings of the court would be read first, and then I would have an opportunity to read my ruling at the end. After the three rulings were given, the Chief Justice, who is the head and has been the head of the quorum, announced that the court was taking a recess and that we would return in 30 minutes. To my surprise, when we convened after the break, I was informed by my colleagues that they could not join me to read my ruling, as I had done when they were reading the majority ruling. The reason they advanced is that I had not circulated my ruling for them to review. And my response was that we arrived at the decisions in all the rulings. We already arrived at our decisions. We already made the rulings. What is contained here are the reasons why we made the rulings that we made. While it is good practice for a member of the court to circulate their draft ruling to colleagues. There is no law in Uganda that I'm aware of that requires me to do so. I would have loved to circulate my draft to my colleagues before. But as you heard from the rulings, the 45 days that the Constitution requires us to finalize this matter constrained my ability to do so. Nevertheless, the whole court was aware of my decisions in each of the 3 applications that were called today. So I'm very surprised that the Chief Justice of Uganda has chosen to use barbaric means and to use his powers in the manner that he has chosen to do so. The Chief Justice had further directed me that my ruling will be read at a later date, that he would choose to appoint, and after he and the other members of the quorum had probably vetted my ruling. I found that order unconstitutional, and I chose to disobey it. When I was appointed a judge of this court in 2009, I swore to uphold the Constitution of Uganda, and I also took the judicial oath. And I am acting based on those undertakings I made. I felt it my constitutional duty to disobey the orders, the unlawful orders of the Chief Justice, and to fulfill my duty as a member of this quorum to deliver my decision within the 45 days that are required under Article 104. With those remarks, I will now proceed to read, in summary, my consolidated reasoned rulings. The petitioner, or before I go to that, of course, on the directives of the Chief Justice, he ordered that all the microphones be switched off, that this tent should be closed, and I want to thank those who gave me directions to an open entrance. But even with this court being closed, this tent, which we turned into a court being closed, I was ready to read my ruling under the mango tree shade. So with those opening remarks, I want to now proceed with reading my ruling. The petitioner, Kyagulanyi Ssentamu Robert, herein referred to as Kyagulanyi, filed this petition on 19 February 2021, challenging the outcome of the presidential elections that were held on 14 January 2021. He filed the petition against A, the first respondent, Yoweri Museveni, Tibuhaburwa Kaguta, herein referred to as Museveni, who was declared the winner of the 2021 presidential election, the Electoral Commission, herein referred to as the Electoral Commission, and C, the third respondent, the Attorney General, herein referred to as the Attorney General. I've talked about the representation of the parties by their lawyers, and I will not read it. Background. The background to this petition is that Kyagulanyi contested with 10 other candidates in the 2021 presidential elections. The elections were organized by the Electoral Commission and were held on 14th January 2021. On 16th February 2021, the Electoral Commission declared that Museveni had obtained 5,851,037 votes in the 2021 presidential elections, which amounted to 58.64% of the total valid votes that were cast in the said elections. The Electoral Commission then declared that Museveni, having obtained the highest number of votes and more than 50% of the valid votes cast, had won the 2021 presidential elections. The Electoral Commission also declared that Kyagulanyi had obtained 3,475,298 votes, which amounted to 34.83% of the total valid votes cast. The Electoral Commission further declared that the remaining 8 candidates obtained the following votes and percentages. I will not go over them. Kyagulanyi was aggrieved by the declaration by the Electoral Commission of Yoweri Museveni as having won the 2021 presidential elections. On 1st February 2021, he filed presidential election petition number 1 of 2021, in which he made the following allegations. 1, that the elections was invalid on grounds that it was not conducted in accordance with the principles laid down in the provisions of the Constitution of the Republic of Uganda, the Presidential Elections Act, the Electoral Commission Act, bear with me, other relevant laws, and that the non-compliance affected the results in a substantial manner. 2, that the election was invalid on grounds that offenses under the Presidential Elections Act were committed by the first respondent or with his knowledge and consent or approval, and that the entire electoral process was characterized by security agencies, in brackets UPDF and UPF, committing acts of murder, causing grievous harm, violence, abduction, and intimidation against the petitioner. On 9th February 2021, I joined my colleagues on the quorum hearing Presidential Election Petition number 1 to disallow Kyagulanyi's application, seeking leave to amend his petition to this court, where he had challenged the declaration of Museveni as the validly elected president in the elections that were held on 14th January 2021. I have since had the opportunity to read in draft the majority ruling of this court, giving the reasons why Kyagulanyi's application for amendment was not allowed. With all due respect to my colleagues, I do not agree with some of the reasons for the decision I arrived at with respect to the application for amendment of the petition. I'll begin with the law. I entirely agree with my colleagues that the law governing presidential election petitions in Uganda is found in Article 104 of the Constitution of Uganda, Section 59 of the Presidential Elections Act, and the presidential election (election petition rules) made thereunder. Article 104 provides in the relevant part as follows. I will not read it in the interest of time. On the other hand, Section 59 of the Presidential Elections Act also provides for challenging the outcome of the presidential election in similar terms as Article 104 of the Constitution. I have not found it necessary to reproduce it here, with the exception of subsection 111, which provides thus: the Chief Justice shall, in consultation with the Attorney General, make rules providing for the conduct of petitions under this Act. It's clear from the above provisions that both the Constitution and the Presidential Elections Act require the following. 1, that a petition challenging the outcome of a presidential election should be filed by any candidate who is aggrieved with the result declared within 15 days from the date the challenged results were announced. In this particular case, the results of the 2020 presidential election were declared by the Electoral Commission on 16th January 2021. 2, that once a petition has been filed, the court should expeditiously inquire into and determine it and give its reasons for its findings not later than 45 days from the date the petition was filed. 3. The Presidential Elections Petition Act gives power to the Chief Justice in consultation with the Attorney General to make rules providing for the conduct of petitions. Turning to this particular application, it's not disputed by all the parties that Kyagulanyi, the petitioner, filed his presidential election petition on 1st February 2021. In their pleadings, some of the respondents contended that Kyagulanyi's petition was bad in law because it was filed after the expiry of 15 days from the date the election results were announced. It's indeed true that 1st February, when the petition was filed, was beyond the 15 days after the declaration of the presidential election results. However, it's also worth noting that the last day of the 15 days fell on a Sunday, which is not a working day. Secondly, the Chief Justice had not yet given directions for the record registry to be open on Saturday and Sunday, as is mandated under Rule 12(2)(c) of the Presidential Election Petition Rules. Nevertheless, in this case, the Chief Justice directed that the filing could be done on a Monday, 1st February 2021, and the petition was accordingly filed in court on that day. During the hearing of the application for amendment, counsel for Kyagulanyi relied on the following provisions of the law stated in the notice of motion. I will not read them. Relying on the provisions, counsel for Kyagulanyi contended that the provisions give power to the court to allow his application. He further relied on the following grounds briefly stated in the same notice of motion. 1, that the applicant filed a presidential election petition on 1st February and served it on the respondents. 3, I'm skipping some of that filing of 2, that filing of pleadings in the petition was still ongoing. 3, the amendment to the petition is necessary to enable this court to effectively investigate and completely determine all questions involved in the petition. 4, that the respondents shall not be prejudiced by the amendments to the petition. 5, that the proposed amendment to the petition did not raise a distinct cause of action in the place of the original. 6, that both the original petition and the proposed amended petition concern the same claim of right. 7, that it is in the interest of justice, equity, and fairness that the applicant be granted leave to amend his petition. Kyagulanyi's application was further supported by his own affidavit and an affidavit by his advocate, Tuliasima Geoffrey, and 2 supplementary affidavits sworn by him. In his affidavit of 8th February 2021, Kyagulanyi repeated the grounds in his notice of motion and further deponed as follows, and I've laid out what he said. In the said affidavits, Kyagulanyi deponed as to the reasons why he was seeking an amendment to his petition. The supporting affidavits of his counsel, Tuliasima, also deponed to the same facts and the fact that counsel could not access Kyagulanyi at his home for 10 days after the election results were declared by the Electoral Commission. He relied on the decision of this court in Amama Mbabazi versus Yoweri Kaguta Museveni and 2 others, where this court allowed the petitioner to amend his petition. He also relied on other decisions of this court, which have. The applicant further relied on Rule 22, 44, 42 and 44 of the Supreme Court rules. I've not found it necessary to reproduce these rules. This is because Rule 21 of the Supreme Court rules provides that they shall apply only to appeals from the Court of Appeal. All the 3 respondents, Museveni, Electoral Commission, and the Attorney General, strongly opposed this application. Relying entirely on non-Ugandan decisions, the respondents contended that the Constitution does not allow for amendment of an election petition outside the 15 days a petitioner is allowed to file. Secondly, they contended that although the applicant's movements had been restricted for 10 days, he still had access to his lawyers. Thirdly, they contended that Kyagulanyi's restrictions did not affect his ability to instruct his lawyers to prepare and file his petition. Fourthly, they opposed the application on grounds that the amended petition was introducing a new cause of action, that is the alleged lack of qualifications of Museveni, the winner of the elections, to stand for and to be elected as the President of Uganda. I have noted in the majority ruling of this court that they agree with the submissions of the respondents. With all due respect to counsel for the respondents and my colleagues on this quorum, I do not subscribe to the alleged legal position that a presidential election petition cannot be amended after the expiration of 15 days following the declaration of those results. As I noted earlier, all the respondents conveniently ignored the binding precedent of this court over Mama Mbabazi, where we allowed the petition to be amended. The respondents did not canvass this issue, nor the issue why the court should not follow this earlier precedent. While it is true that Article 104 of the Constitution and Section 59 of the Presidential Election Petition do not expressly provide for amendment of the petition, none of the said provisions expressly bar this court from allowing amendments. In the past, this court has jealously guarded the jurisdiction conferred on it by the Constitution and refused to allow arguments by parties praying to the court to hold that its jurisdiction was ousted. And I give an example of a case where this court declined 201 former employees of 4GS Security Services. This court declined to find that the jurisdiction of the High Court to handle employment matters had been ousted by the Industrial Court, which had not yet been set up for 5.5 years after the law was enacted. If this court declined to do so in a case where the law specifically provided otherwise, I would not subscribe to a view that this court's power to grant leave in proceedings before it could be ousted by a mere deduction that the power to amend is not expressly provided for. This court has always upheld its inherent jurisdiction to do justice to all parties as the circumstances of the case before it would warrant. In summary, I state that that is not one of the reasons I disallowed this application. Thirdly, the applicant also relied on Section 98 and 100 of the Civil Procedure Act, Rule 15 of the Presidential Election Petition Rules, and Order 6, Rules 19 and 20 of the Civil Procedure Rules. With the exception of Section 100, I found the remainder of these provisions applicable. Of particular interest is Order 6, Rule 9 of the Civil Procedure Rules, which specifically vests in this court power to allow a party to alter or amend pleadings, his or her pleadings. The rule provides as follows, and I've quoted it. The rule was applicable to a presidential election petition by virtue of Rule 15 of the Presidential Election Petition Rules, which provide that the Civil Procedure Act and rules made thereunder shall apply to presidential election petitions with such modifications as may be necessary. It's, however, important to note that while this court had the authority to allow the applicant petitioner to amend his petition, Rule 19 uses the word may, thereby giving the court discretion to grant or not to grant the application to amend. I will now turn to the issue of whether or not the application should not be allowed, because the proposed amendments would be introducing a new cause of action. The respondents contended that the proposed amendments of the petition, which was introducing the issue as to whether or not Museveni had the necessary qualifications provided for under the Constitution to be elected President of Uganda, was introducing a new cause of action after the expiry of the 15 days limitation period for filing a presidential petition. It is trite that the issue of persons who are eligible to stand for election as president is a matter of law. These qualifications are spelled out in Article 102 of the Constitution and repeated in Section 4 of the Presidential Elections Act. Section 102 provides as follows, and I have quoted the article, you can access it. On the other hand, Article 104 gives the right to an aggrieved candidate to petition the Supreme Court on grounds that the person who was declared as the winner of the elections was not validly elected. That being the case, the cause of action granted to an aggrieved candidate is to bring an action challenging the validity of the election of the successful candidate. I therefore do not agree with the respondents and the majority justices of this court that by the petitioner raising the issue of qualifications of Museveni, the winner of the 2021 election, or lack thereof, he was seeking to introduce a new cause of action. Contrary to the respondents' contentions and the majority of the court's view, I believe that the issue of qualifications of the president is not subject to the 15-day limitations rule. A petitioner or even any other person could have raised this issue before the presidential election was held or even after the elections are completed. In my view, a challenge to the qualifications or disqualifications of a presidential candidate cannot be extinguished on the basis of Article 104. Having been provided for in a separate article, it was my view that the petitioner did not, it is my view that the petitioner did not need to amend his petition. I'm aware of the provisions of Section 59(6) of the Presidential Elections Act, which provide as follows. 6. The election of a candidate as president shall only be annulled on any of the following grounds if proved to the satisfaction of the court. And B, 1 is non-compliance with the provisions of this act. If the court is satisfied that the election was not conducted in accordance with the principles laid down in those provisions, and that the non-compliance affected the results of the election in a substantial manner. B, that the candidate was at the time of his or her election not qualified or was disqualified for election as president. C, that an offense under this act was committed in connection with the election by the candidate personally or with his or her knowledge and consent or approval. I note that Parliament was granted power under Article 104 of the Constitution to, quote, make such laws as may be necessary for the purpose of this article, including laws for grounds of annulment. Pursuant to this section, Parliament enacted Section 59(6)(b), quoted above. Although Parliament was acting within the powers granted to it under Article 104(9) of the Constitution, the inclusion of the ground of annulment in Section 59(6)(b), without referencing Article 102 of the Constitution from where it is derived, led to the unfounded view held by the respondents that a successful presidential candidate's qualifications can only be challenged under Article 104 of the Constitution and Section 59(6) of the Presidential Elections Act. I hold the view that a constitutional challenge based on the lack of qualifications of an elected president, as provided for under Article 102, can be made, 1, before the election is held, 2, during the presidential election petition filed under Article 104(1), or at any time after the 15 days have lapsed, 15 days under Article 104 have lapsed without a petition being lodged in the Supreme Court, or 4, after the conclusion of a presidential election petition. It goes without saying that such a challenge is not brought within, such a challenge which is not brought within an Article 104(1) petition could be brought under Article 137 of the Constitution. I'm aware that my views above differ from the ruling of the court in this application, in which I concurred and where we unanimously ruled as follows with respect to this issue. Court finds that the issue of qualifications of the first respondent in the proposed amended petition is a new matter which comes outside the limitation period for filing a presidential election petition. Therefore, we disallow it. Having critically reviewed the constitutional provisions I have cited above, I have come to the conclusion that I arrived at a wrong decision to rule as above. While this is so, I'm aware that Article 132(4) of the Constitution gives this court a right to reverse itself in appropriate cases. It provides as follows. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. I'm further aware that although this right is vested in this court as a whole, this article does not exclude the possibility of a single justice of this court to depart from a position he or she has taken earlier. This is especially so in a case like this one, where there is a decision of the whole court and where therefore there is no option for a reference from a decision of a single justice, as is in the case in the other cases where the court is exercising its appellate civil and criminal jurisdiction. Other than the above, I stand by the rest of the ruling of the court rendered on 4th February 2021. Having listened to the submissions of the applicant, I was convinced that he had made out his case that the restrictions on his movement by members of the police and army had adversely impacted on his ability to instruct his lawyers and to also prepare for his petition. I was further convinced that the applicant had been, quote, arrested in his house for 10 days by the police and the army, thereby losing 10 critical days out of the 15 days he was granted under the Constitution to lodge his petition to this court. The averments of Kyagulanyi and his counsel were validated by the order of the High Court issued in Kyagulanyi Sentamu Robert and Barbara Kyagulanyi Tungo versus Attorney General, Chief of Defense Forces and Inspector General Police, High Court Miscellaneous Cause number 16 of 2021, where Elubu J ordered as follows. 1. The restriction imposed on the applicants are unlawful and their personal liberty be hereby restored. 2. The applicants comply with the COVID-19 SOPs. And 3. The respondents pay the cost of this application. Although I was convinced that the applicant had made out his case for amendment, I was convinced that the non-amendment of his petition would not necessarily be fatal to his case. A review of his petition showed that although he was constrained to prepare and file his petition in only 5 days, instead of the 15 days he was constitutionally entitled to, he had managed to plead the non-compliance with the principles set out in the law and that Museveni the winner had committed electoral offences. As I pointed out earlier, either or both of the grounds, if proved, would be sufficient for this court, after concluding its inquiry into the petition, to make any of the orders it is permitted to make under Article 105 of the Constitution and Section 59(6)(b) of the Presidential Elections Act. The second reason related to the remaining proposed amendments. Having reviewed them from the copy that was attached to the application, I concluded that all those matters could be brought in within the petition as evidence. The third consideration that I took into account was the constitutional dictate in Article 104 of the Constitution for this court to conclude its inquiry and to make its decision not later than 45 days from the date of filing the petition. Although I was convinced that this obligation did not require the court to refuse a deserving amendment, any time saved by the court without prejudicing the parties would be in the interests of both parties, as it would give the court more flexibility to manage the hearing, inquire into the petition, and to render its decision. I will now proceed to read my reasons for allowing Kyagulanyi's application for extension of time to file his evidence in support of his petition. By 2021, Robert Kyagulanyi made a formal application for extension of time to file the remainder of his evidence. He filed miscellaneous application number 4, seeking for the following orders. 1. The time granted to the applicant for filing additional evidence in support of the petition be enlarged by 1 extra day to enable him file and serve all his compiled affidavits. 2. The respondents be given some extra days to file responses. 3. Costs of this application be provided for. On 19th February 2021, this court, by a majority of 8, dismissed the application while allowed it for the following reasons. The application was supported by the affidavit of sworn by Kyagulanyi and was based on the following grounds laid out in the notice of motion. One, that the applicant filed the instant presidential election petition on 1st February and served it on the respondents. 2, that the filing of pleadings in this petition is still ongoing. 3, the filing of the additional affidavits in their petition is necessary to enable this honorable court effectively inquire into and determine all questions involved in the petition. 4, there are prevailing special circumstances that warrant the grant of this application. 5, the applicant has brought this application without any delay. 6, that the respondents shall not be prejudiced by extra time being granted to the petitioner to file and serve the additional evidence in the petition. And 7, that it's in the interests of justice, equity, and fairness that the applicant be granted extra time to file and serve the additional evidence in the petition. The application was supported by the affidavit of Kyagulanyi, where he listed the following additional grounds. And I'll just highlight that on 14th January, upon casting my vote in the general elections, I went back and interacted with our party officials on the progress of the elections, but around 1 p.m., I noticed that my telephone signals had been disabled. 3, that when I and my family woke up the following morning of 15th January, our home had been surrounded by the police and military personnel, effectively placing us under house arrest for the next 10 days. 6, that I'm reading, that when I attempted to move out of my home to seek for legal advice from my lawyers and the decision of my party leadership organs on the next course of action, the police and military officers that had surrounded my house refused me from doing so. And there are many reasons which are reproduced here in his affidavit. I will not read all of it. Paragraph 30, that I will start with. I'll start with 29. That consequently, the decision from the Chief Justice through the Land Registrar was to the effect that, save for the evidence in 13 copies of Volume 2, out of which 7 copies had been received by 5 p.m. on 14th February 2021, the other copies of evidence would not be received, thus leaving the additional affidavits of evidence under Volumes 3, 4, 5, and 6. Copies of indices of the affidavits in Volumes 3, 4, 5, and 6 are herewith attached and marked as annexures E, F, G, and H. Paragraph 30 read that I immediately instructed my lawyers to file this application. But on 16th February, having been a public holiday, they told me that they would file the same on the following day of 17th February. Paragraph 32 read that